simply a staff attorney getting an idea in his or her head, let's send a subpoena out for that, can have huge ramifications, extraordinary cost, extraordinary burden to the recipients. And so that's where I worry a little about this sort of entrepreneurial idea that, you know, just on a whim and an idea, you can send out a subpoena.
But I reject the notion that it's just on a whim, or, I mean, people act rationally at the SEC, and an entrepreneur...
It's a rational whim.
It's a rational whim. But again, even like sending out that subpoena or come hither letters or other suites of those nature, before those actions are undertaken, there is decision-making and review, just because as a government agency, we have very limited resources. So there's nothing to gain by going ahead and doing that. Plus, there is an understanding, appreciation, and respect for the power of our subpoenas and what that means on the other side in terms of cost, reputational consequences, etc. So I don't think they're ever done on a whim or without, you know, very good cause.
So speaking of process, there's this national task force on fraud, on accounting fraud, right? And so how does that affect what your office does? Because that's based out of a different office, I believe.
Well, it was originally headed by David Woodcock, the regional director of the Fort Worth office, who is leaving, and is now headed by the person who was the co-head, Margaret McGuire, in DC. But it does have representation on the task force across the regions, including we've had somebody from our office, an attorney as well, as we previously had an attorney CPA on the task force. And so as much has been discussed about the task force, it really is sort of an incubating task force to try to identify potential new matters and investigations, and then get assigned out to the regions.
So incubating sounds all like entrepreneurial. What on the defense side, have you seen any results or any changes because of that task force? Mark?
I think it's actually, I have great deal of respect for how the program got off the ground, and it gets back to proportionality. I've had a few run-ins encounters with the task force, and it has been a more modified way of taking a look at your tires, triaging what may or may not be in action. So I think that model is very successful. You don't get 20 subpoenas on the first day. You have a meeting to talk, and sometimes the staff realizes there's nothing there. Sometimes they escalate, and I think it's been a very good process. So I have no problem with it. What they did later, that's
and I think that it does create an opportunity, and one of the challenges, and in any case when the subpoena shows up, the request shows up, you never really know what the source is, you don't really know what the degree of seriousness is, you don't know whether it's just a kicking the tires kind of exercise or something specific to your client. And so part of the challenge in very early days is to try to figure out, okay, well, what does this mean? Is this something that is the result of a data analytics kind of exercise? Is it the result of a sweep? Is it the result of a specific complaint relating to this company, and so on?
Can you find that out right now?
You know, sometimes you can, sometimes you can't. It can be very frustrating. And one of the, now that I'm on this side of the table, I will say one of the biggest challenges and the biggest areas of frustration is, if you have a client which is an entity, and wants to do the right thing, and wants to know if there is some ongoing misconduct by one of its employees, and recognizes that that is the responsible thing to do, you need some information from the government, from the SEC, in order to be able to look into these things. And I've had any number of circumstances where the SEC is just a black box and they won't share anything, presumably for legitimate reasons, but it can put companies in a very difficult position.
It's very dependent on the staff attorney. Sometimes you get the black box, sometimes you get some, let me explain exactly what's going on here. It helps if you get the ray line in the matter of certain illegal actions or something. Okay, they're looking at a whole bunch of stuff, and it's not naming your client. So, but it's very dependent. Some staff will tell you an awful lot, and some are like, I can't tell you anything, here's what we need.
I want to switch to another priority, something we've been reading about for a long time and haven't seen a lot of enforcement. Maybe it's more of an examination issue, which is cyber. So Gina, what's going on either on the enforcement or the examination side in terms of cyber disclosure?
Cyber disclosures or cyber
disclosures?
Because I think that cyber disclosure is a very small fraction of the enforcement attorneys or maybe the practitioners up here kind of deal with it. Cyber is a huge issue, as you can imagine, for because privacy for registrants, if you think about the type of information that goes in the registrants. And so that is a headline story every day. You hear about cyber breaches. How do you make sure that registrants, entities are maintaining security and that people can have faith in their ability to put their money in certain places. That's for a lot of the financial regulators. This is a huge issue. So I see a lot on the OC side, and we put a lot of resources into that. And if you look on our, at the SEC.gov website, if you look at OC, that is a huge priority. But it's also a priority on the enforcement side. And I think it comes as to disclosure. I don't think of that as particularly just like a mind. Like I don't think of that as always top of mind. How will the issuer disclose a cyber breach? Are they doing that? I think that the risk when it comes to cyber issues is so much greater than that, greater than issuer disclosure, but it's an interesting issue. I think it sounds like a good issue.
So Elaine, for defense.
I think that cyber security is definitely an area of concern, and I appreciate that the SEC has come out with, investment management came out with a paper recently about things that registrants may wish to consider, and the cybersecurity exam suite summary told about percentages of firms that were doing various things. But my question is, how does something like that become an enforcement issue if your firm is not doing what is suggested or what some percentage of other firms does?
I mean, I wouldn't think so. I think the theme that emerges on the OC side and looking at the policies and procedure at its core, it's one of reasonableness. So there can't be an across-the-board rule because just like with compliance procedures, they need to be reasonably tailored to the nature of the business, the risks of that business, the risk of that particular firm. And so, like with all things, it really is a reasonable test based on the facts and circumstances. So,
but I mean, why should the SEC be suing someone if they think their cybersecurity is unreasonable? I mean, where in the securities laws does cybersecurity come in?
Well, it comes in Rule SP for customer protection, and then the amendment to that rule where you do have to have policies and procedures to protect against security breaches as well as protect the customer's privacy.
But that's my concern. I'm sure that everyone has policies and procedures, but they may not be good enough. You know, what if they're,
But the question is whether they're reasonable under the circumstances. And every day as lawyers, you try to make the best assessment you can, not just with the benefit of hindsight, but at the time, did the firm in good faith create a system of checks and balances, policies and procedures that were reasonable to detect and prevent the violation or the breach.
And the SEC is some expert on, what's cyber is required. I mean,
Now it is like.
Okay, well, that's my question.
So let's switch topics. I think we have a streak going today. I don't know if people have noticed it. Every single panelist talked about administrative proceedings. So I was thinking, should we talk about it? Well, of course we should talk about it. Keep it going, right? I mean, every single panel is going to do it. So I did hear, or I did read that one official has called it the new normal. And there was a discussion on at least 2 different places today about the new guidance, which I read last week. And the SEC is all about disclosure, right? That's what it's all about, pro-disclosure. I thought the disclosure, someone at my table suggested this, the disclosure should have read, the guidance should have read, we will go where we think we have the better chance of winning.
Right.
Now, maybe that's what it should have said, but maybe that's okay. Maybe there's nothing wrong with it. I don't know if you can do it. So Gina, what's your reaction to is it the new normal? Is that really going to be now just commonplace more often? And and do you think about it that way? I have a better chance of winning in this forum, so I'll just do what any plaintiff or prosecutor would do.
I don't think of it that way, I have to say. And so I guess your concept of winning is different than our concept of winning. Everybody on this panel has had had to do in the position that we were in is winning is not just having a verdict go your way. Winning is having, doing the right thing and having, we have a three-part mission at the SEC, and that's investor protection, maintaining fair and efficient markets, and making sure that we're able to capital raise, right? And so that's our mission. That is winning to us. So at the end of the day, if justice is done, that is winning to us. And so if we get a bad verdict, have we lost? And on some level, yeah, we've lost. But we have. That's why we have a different client. We have a different ability. So if we just look unfair and like that, we just want a certain resolution at any cost, and we'll do it at any cost. That's not winning to me. So the idea that we will just that we will file a case where we can win, I actually think we have resource issues, and there are many reasons why we file cases where we file cases. And I think that the guidance is pretty clear about what factors go through our mind when we choose to file a particular forum. That being said, we are also a plaintiff, and so we bear the burden of having to prove our case, and we do choose the forum.
The question, one of the questions I have never really heard satisfactorily answered is how does the SEC explain the great disparity in outcomes between the administrative forum and the district court? I mean, it's a tremendous disparity in success rates.
When you say tremendous, so 80% is about our success rate in litigation, right, in all trials, everything that goes to trial. And I think the success rate over the last few years has been, it's 90 and 70, right? So it's not 10% each way. I mean, I just think, how do you explain it? I don't think that the explanation, well, I mean, you file the best case you can. Is it outcome determinative? It's not like every case is filed as an AP. It really was.
Well, but I would add something to that. A large proportion of the administrative proceedings are follow-on proceedings, often litigated over the bar, the collateral consequences once we've obtained an injunction against an individual. So it seems common sense that you are then going into a proceeding where the liability of the respondent in the administrative proceeding to the underlying violation has already been resolved. So the fact that, and those people who then continue to litigate, that we would have a higher percentage than sort of the litigation at the outset, it seems fairly consistent. It doesn't seem unfair. And plus, I think, looking at statistics can always tell whatever story the person using the statistic wants to tell, but at the end of the day, I'm not really understanding how there is some difference in fairness in either proceeding.
Well, how about the right to jury trial? I mean, that seems to me a pretty fundamental difference that we have always thought of as a bedrock of our judicial system.
Right to deposition is obviously a big deal. But I mean, in terms of the guidance, I think it's great. I mean, anytime that the government gives you guidance, that's a good thing. But I think it was sort of addressing the wrong question. If my client is about to be sued in one form or the other, my question is less, how did they get there and how was that decision made? The question for me is, how do we respond in that form? And as Randall said, very different approaches, very different rights depending on the form. I think that's
so for that reason, one thing I'd like to see in this release that's not there is one of the factors the SEC is going to consider is the need for discovery and the time it will take to get to trial.
But that isn't the guidance.
Well, not as an explicit factor that the SEC will.
It's an example of one of the factors that are considered. And also one aspect that I think is
from
lost.
the SEC's perspective. From the SEC's
Well,
perspective.
but this is what, but part of, well, as somebody who is sitting to my farthest left possible, when he was my boss, he did tell me this aphorism that justice delayed is justice denied. So,
You're the one who started that.
This is all a matter of balance. Balance and perspective.
But that prior to the initiation, when we turn over our investigative record as well as Brady, Jenks material, etc., we often have the following conversation with the respondent. We're assuming you don't want us to reproduce back to you the 1 million pages that you produced to us during the investigation, correct? So that illustrates the point that all the hue and cry over, we have no discovery and the staff has investigated for 3 years. Well, the discovery that you're complaining we have that you don't have access to is the discovery you produced to us. And for the most part, and through the Wells process, at least, speaking for me and my office and Lori Echavarria, who's the head of our enforcement program, we are transparent. The only time we don't turn over information during the Wells process if we have reason to believe that the information is not going to be used in good faith. So there's no advantage to the staff to not being transparent with what the evidence and the facts are. And this goes to Gina's point. It isn't just gotcha or to win at all possible costs. Believe it or not, the people that work at the SEC are really committed to trying to do the right thing. You may not agree with what the right thing is, but there's no big surprise that occurs.
Let me just ask one question about this. What if I came to you and said, look, I know you can charge my client. You could go administratively or through court. But from my client's point of view, having some depositions or some other kind of limited discovery would be better, would be a fairer outcome. Do you take into account what the person who you're going to charge would be interested in?
Well, if you came to me, I'd be curious what your reason. If it seemed reasonable and for some reason, like that would lead to a better outcome, I wouldn't say, no, it's our investigative record and you don't have any rights. I don't think...
You take it into account.
I mean, I would speak, again, the views I expressed today.
And what
I had a question and answer right there.
And what if we said that one of the avenues of discovery we wanted to be able to pursue was depositions of other SEC staff members to get into, for example, a market practice and whether it's fair to charge somebody with a particular market practice that the SEC may have known about and sanctioned for years. And so what we want to do is go in and take depositions of folks in Corp Fin.
Well, we would say no, just like we would oppose that.
But doesn't that illustrate the point? I mean,
No,
federal court.
that's not evidence that would be admissible likely by a district court or the
I
DOJ.
disagree.
Yeah, in federal court, you've got a very good shot at getting that evidence. And I have the case right now where we've gotten, that court has ordered that SEC witnesses sit for depositions.
And I've taken depositions of members of Gina's office in a federal court case. I mean, that's important. And if I'm in an AP, I'm stuck.
Well, I'm just
This goes to
curious,
Jordan's point.
how come there's only the outpouring of this vitriol from the defense bar now, when the administrative proceeding has occurred for years against regulated entities, some of whom are among the biggest financial institutions in the world, but yet that wasn't trampling
Well,
on
I think
their court process?
everybody accepts that if you're directly regulated by an administrative agency, you have to submit to their administrative process.
But somehow you're all attacking the fundamental, you're claiming is just inherently fundamentally unfair, whether you sign up in advance to it or not.
If you're not an SEC registrant, that's right. I think it is, you didn't sign on for it. If you're an SEC registrant, you sign on for being regulated by the SEC, or it could be EPA, or it could be Department.
You don't give up your right to jury trial when you become a regulated entity with the commission.
You know what, why don't we leave something for the next panel? I'm sure they're going to talk about this, and it's a very interesting debate, but we do have a few other topics. So the next topic, probably not as controversial, is the use of analytic tools to generate leads. And I saw a quote from, I think from Andrew Sorrell, who said that the use of data over the past few years has been transformative, that it's really changed the way enforcement works. Gina, maybe we'll start with you.
Sure.
In what way has the use of analytics changed what your office is doing?
I think it's changed what we do. I think it's changed very much what you do. I think the idea that big data is out there and that it's a very powerful and compelling source of evidence and patterns is something I'm sure you analyze, and we at the SEC need to do that as well. I think that investors would think we were falling down if we weren't using the data that we have, or the data that's out there, or any of the tools that we can. I've seen this used in the insider trading space, the amount, you can imagine the amount of trading data, looking for parallel trades, trying to detect patterns and trying to back end what exactly happened when you look at big amounts of money that are made.
Do you use this to try to find accounting cases as well? Do we compare across different companies, their accounting treatments, that kind of thing?
I would think that is an important source of data. If you can imagine the amount of filing that issuers provide to the commission, everything that's in there, the financial reporting and audit task force, along with DERA, has done some great work.
DERA, what's DERA?
The Division of Economic Research and Analysis.
And Michelle, in terms of your office, same kind of thing?
Yes, so we get a lot of the fruits of the analysis, and that's a way to also, for some of the more technical cases or non-scienter cases, it's a way to identify a group of potential violations that the staff can investigate and try to resolve on an expedited basis with not a lot of resource commitment.
So have any of the formers seen this in action?
I have, and I think what you have to do, and this is actually an advantage, is you will get a focused, narrow request, and so you can address it in a narrow and focused manner. And if you can really show the staff there's really nothing there because they're doing this based on statistics and analytics, the matters can go away. And so you can't stop it, but you have to turn it to your advantage to say, okay, you're interested in this issue, let me give you the documents on this issue, then you can talk to these two people and I can explain the whole thing to you. And I found the staff, actually in both offices up here, very responsive to this way of dealing with it. They don't want to waste time.
Okay, let's go to another topic that's been mentioned today, a little more controversial than the one we just discussed, which is whistleblowers. So we all know about the uptick in whistleblowing. We all know about compliance officers now, and people who are in the internal audit function getting rewarded and so on. So maybe I'll start with you, Michelle, on this one. In what way has this changed the practice? Because it's actually relatively recently that it's gotten to be such a big deal.
I think the most profound way it's changed the practice has just been in the quality of the complaints that come from whistleblowers. So prior to the enactment of the Office of Whistleblower under Dodd-Frank, we did have whistleblowers, and obviously we have a constant influx of complaints, tips, and referrals from the public. But just with some of the incentives that are provided under the whistleblower office, and the incentives obviously that counsel who represent the whistleblowers have, it sort of self-selects into oftentimes more credible claims.
When you get those, do you alert the company, gee, we've heard something from the company, or you just, we're just asking questions, we're not going to tell you why?
Well, we're not allowed to let the company know. No whistleblower has complained, so no, we don't do that. But oftentimes, the company is aware of it because in most instances, not only do they file the complaint with our whistleblower office, but in many instances, they also go to the FBI, the U.S. Attorney's Office. So in a fair number, I don't know if it's a majority, but in a significant number of instances, the companies are already aware that there is.
And in cases where you have a whistleblower, do you proceed in a different way, more quickly, or asking for documents more?
It depends. It really depends on what the nature of the whistleblower complaint is. They really range from a one-page, pretty brief summary to we get 50, 100-page submissions with exhibits that obviously their attorney has spent a great deal of time and effort on. So we can review those and then make a determination, and in that instance, we may be able to begin our investigation more quickly.
So turning to the formulas, I'm going to ask Mark to start. In light of the fact that there are all these whistleblowers out there, what does that do with responding?
It keeps companies on their toes, which can be positive and negative. I think on the bright side, I think most companies now recognize it has turned out to be the case, as many at the SEC were saying at the time. Most whistleblowers, even with a $30 million check they want to first go to the boss, want to go to the company and see if they can fix a problem they recognize. And it gives companies an opportunity to try to address it and fix it. And I think companies are taking it much more seriously than we did in the past. And I think they're doing a better job of letting the whistleblower know, by the way, here's what we've done. So they don't go to the government. The trade-off is you never know if ultimately somebody's talking to the government or you haven't satisfied the whistleblower. And it changes the equation. I think most companies and those of us who are helping them out, there are a lot of things that are raised that really don't look significant or don't look like they would be significant to the SEC. But the downside of not looking at them thoroughly or proactively self-reporting to the government have gotten so much higher because the odds of somebody talking to the government are much higher. So you really need to be prepared. If I get the call from Gina saying, we've got this whistleblower, what have you done? I need to be prepared to say, we've looked at it and here are the millions of dollars of resources we've poured into it because the risk of not doing enough is so high.
And what do you do when she says, why did you come to me?
Exactly.
And,
That is what I'm saying.
and at least be able to document the file and say, we have done a very thorough analysis, we brought in insiders, independent people, and there's nothing.
Didn't want to bother you, you're busy.
And there's never anything.
I think the other dynamic that has changed is that it does sort of understandably, in many cases, I think, make it harder for the staff to close a matter promptly because they feel like, they really need to, particularly if it's a whistleblower that's providing very detailed information, they really need to chase down, every possible source of information, to chase down every allegation. I've had cases where there's a real back and forth, and you can tell that what the staff is doing is going back to the whistleblower and verifying what we've told the staff, asking if they have any further corroboration, and so on, which is all appropriate. And I've found that I think the staff is actually interested in and willing to have those sorts of discussions, but it does make the process sometimes longer than probably needs to be, at least from our perspective.
Gina, do you have comments on this?
No, I do think the whistleblower program, which is really instituted by Congress, right? I mean, that's a game changer. And I think probably much more on the defense side than for us. I think we always, we take whistleblowers seriously. Anybody can come to us. I know they're incentivized to come to us. I don't think it will, when I look at the Office of Whistleblower Report, which I think is a great report to go through, I don't think it's going to surprise anybody up here or anybody in the audience in California is by factor of 2 the highest number of complaints, of whistleblower complaints that domestically than any other state in the country.
Is that because they're entrepreneurs?
But so I do think, and it's real. I think that we value that. It does keep, as Mark said, it does keep companies on their toes. And I think it's a great check there for compliance programs, for people who might have thought, I'm just going to take my chances and not report this. I'm going to take my chances and not have a great program. I think the risk to that is much higher.
How often does it occur where a company will self-report something and you say, thank you for self-reporting, but we don't want you to do anything else at all? What you've reported to us and the steps you've taken thus far are satisfactory. We have no further questions.
Don't all speak at once.
Yeah, that it occurs to me that's happened multiple times that I can think of just right off the top of my head. Like, people have come in, they have, in a prepared way, this is what we found, this is what we heard, this is what we did. And there's nothing there. And here, have at it. And a lot of times, we're just under-resourced. We don't have the resources that everyone has. Our region, just to think of it, it's not just Silicon Valley in San Francisco. It's Silicon Valley, it's Seattle, it's Portland, it's all of those states, Idaho, Montana, So, the size of our office and what we can devote our resources to, that is not, so I don't want anyone to think that.
Although if you fall in the sweet spot, if it's a financial reporting fraud, alleged financial reporting fraud by a public company, if it's a disclosure issued by a registered hedge fund manager, things that are high priority areas for enforcement right now, the risk, I think, is pretty high that there's going to be some follow-up work. And again, against the question, the costs are enormous. And most people at the staff, and that's why I think, especially the West Coast offices, the revolving door is a positive. There are a lot of attorneys who come in, have been on the defense side, and understand that saying, well, can we just talk to 20 or so witnesses real quickly, is a major burden. Not every office has that same culture, and sometimes we just need to talk to a few people. That's a few $1 million in some cases. So you're really depending on the staff to try to keep things narrow. Most people do a very good job of it, but not everybody.
Okay, we're going to go on to another topic, which also came up earlier today, which is the KBR ruling, in particular what that means about confidentiality agreements. So KBR, there was an upjohn warning given, but it wasn't adequate. The SEC thought this was going to chill people from reporting to the SEC and chill whistleblowing. So I guess my question for you, Gina, and then you, Michelle, is that just a one-off decision you just see once in a while, or is this, no, when you do your internal investigations, you have to have carve-outs? I think someone before said they'd like to ask someone at the SEC about it, so I'll ask. Is that all upjohn warning, you have to have carve-outs? And beyond that, what about regular old confidentiality agreements? Do they need carve-outs? Is that something you're looking for, or is it that just a one-off?
I don't think it's a one-off, but I don't think that it's changing anybody's sense of what an upjohn warning is. The idea that you're doing an internal investigation on behalf of a company, and you say, I'm not a lawyer, this is a confidential conversation, but that doesn't mean the facts that you give me. You can't go to a government regulator and tell them that. And so by having people sign off on saying, I'm going to keep all the substance of my interview confidential, and I could get fired if I don't, or I can be disciplined if I don't. I think that, regular people sign these things. And does it impede their ability to go to the government? Does it make them feel like, oh my gosh, I can't talk about this to the government. I've been dissuaded, I will get in trouble. I think that it is worth defense counsel or companies. Look through your agreements, read them like regular people do, because they're regular people, they're your employees. And I think the guidance is pretty clear in the order. Those carve-outs don't seem
So I would just like to say we've now changed all our confidentiality provisions. Not for internal investigations, but all of them. But to me, this is regulation by gotcha. There was no harm here. The SEC never before addressed this issue. There was no harm. No employee was prevented from contacting anybody. The company never enforced this provision. The SEC could have announced guidance like it has in other areas, but instead it brought enforcement action against this company.
Well, but Elaine, Chair White gave a speech on this very topic last week, and, she
But
made...
the enforcement case was before that.
Correct, but her point in the speech is that the first time you bring an action to enforce a rule is not regulation by enforcement. The rule is there, and there always is the first case. So I think that's kind of a not very fair challenge to the agency enforcing one of its rules.
So
Why not just say, I think that's what Blaine's saying, why couldn't the SEC just say, yeah, the rule pre-existed, there's no question. But just say, look, it has this implication, and companies, lawyers, you ought to take advantage of it.
Well, but it wasn't as if the application was, an issue of first impression. The rule is pretty straightforward, and the agreement at issue violated the rule.
I go out. That is open to debate how clear the rule is. But if Andrew Strosny, who's here today, had gotten up and given a speech and said, we've seen it, and Sean McKessie had done this to some effect, and started talking, practice has changed. If Sean or Andrew came up and gave a speech everyone would know that they said, look, this particular language, we're starting to see we have a problem. You better believe we'd be telling our clients here, we need to take
So
over.
Mark, that's all historical. Now we have this rule. Okay? So going forward, will you ask, let's say lawyers come in and say, here are the results of my investigation. You say, well, tell me what your warnings were, or your upjohn warnings were, or do we need to say, and here's what we told people? Is that something you're going to actively look into?
I think
I don't want to give you any ideas.
You know, I think every investigation has its own dynamic, but I can see asking for such agreements. And I agree with you, Jordan. Yes, now we're moving forward that we have to look at, and I think it's pretty clear out there. So I think it's an opportunity for issuers, companies, and their counsel. It seems pretty straightforward to me.
It's unfortunate that for a company to litigate, they paid $135,000 to settle this. You can't litigate for that. You know, so they did a cost-benefit analysis. It's too bad that, you know, people can't litigate some of these things, even though they might not agree with them.
As long as it's in an AP.
All right, so we're
That
down.
one seems like it would be right for me.
Maybe it would.
I think.
Although it's a public company.
All right, so we're,
Yes,
well, we can continue this. We are starting to run low on time. So the last question, we're just going to go down the road here, but we're going to end with the two current people, is it seems that the overall tone over the years is that the SEC has become more of an enforcement agency, quasi-criminal agency, and a lot of what we've talked about, you know, fewer protections for defendants in these cases. So if you have a 1-minute comment on that, and then how you deal with that. We'll start with Randall, and each take a minute and come back and we'll give the last word to the two current members.
Sure. So to me, I think that the issue that the SEC should think most about, given sort of all these debates, is the perception of fairness and the appearances. Because whatever the debate is about the constitutionality of use of APs or whether a particular enforcement tool is, in its toolkit, or whether the SEC has engaged in regulation by enforcement, or so on and so forth. I think there's a real question about the overall perception of fairness and the overall appearance of impartiality, and ultimately the degree of public confidence in the agency that results from the various debates. And so I think for those of you who heard Chairman Costa's speech, I think he hit it right on, which is on the issue of APs, which is that I think there are some pretty serious questions of the appearance of fairness.
Right, Mark?
I think there's no question the agency is in a more aggressive position right now. That may be well and good and better for markets, but I think you notice it on the margins as a practitioner. Little things, for example, if you settle a case historically a few days before it's filed, you get a call, it's going to be in 2 days, here's the press release. You can't do much about it, but just a heads up, and you don't get that now. So the last few cases I've been involved in, I get a call saying in 5 minutes you're going to read about this, and literally within a minute the press release goes out. Little things like that where it may not change the dynamic a whole lot, but in terms of clients' faith that they've been treated fairly, the little things do make a difference. And to be, given some thought that there is a voice, an opportunity to talk a little bit more with the staff and managers, even if you end up in the same place, I think give defendants and those facing the SEC enforcement actions a little more comfort at the fairness of the process.
Yeah, I would echo those views. The agency has become sort of quasi-criminal. That's a huge change. And it's happened over decades, go back to the 30s, and it was simply stop the conduct and don't make sure it doesn't happen in the future. Then you have penalties coming in, or you have a civil monetary penalty. What the heck is that? That's a criminal fine, isn't it? Well, no, and there's all these sort of conceptual games that go on, but the reality is it has become more quasi-criminal, and now they're bringing cases in administrative proceedings that we've talked ad nauseum probably for you on this issue. So there is this concern about the perception. I mean, all three of us, and Lane May being fourth, have this perception of the processes aren't perceived as fair. And that's, I think, a real problem.
Speaking as a registrant, or from what I heard from other registrants, I think there's concern about a gotcha mentality from the SEC. And I have heard that in Boston, the office is reaching out and meeting with CCOs and general counsel, and that's very appreciated. But I wanted to read to you what another regulator has done. This is the Federal Reserve Bank. They sent a personalized letter to our Deputy Chief Compliance Officer, dear so-and-so. I'm writing to thank you for completing the SHL report as of June 30th. The overall quality and timeliness of the SHL data you submitted was very good. We appreciate all of your efforts to provide high quality and timely data as it is used for blah, blah, blah. Okay, if you have any questions, please contact us. That's different, you know, that's different.
Just a thank you note, just want to thank you. You can do that.
And an apology too.
Well, we always say please and thank you. And then Jordan, I just reject the premise of your question, that somehow our proceedings are constituted deprivation of respondent defendant's rights. I also reject the notion that the SEC is now some kind of quasi-criminal enforcement agency. It's a civil enforcement agency. Part of the mandate of a civil enforcement agency is to enforce its rules and to serve specific and general deterrence. And that is a guiding principle and a consideration that's taken into the sanctions that we recommend against anybody that we sued. And one thing I do think is very interesting, the dialogue that we have is very one-sided about the deprivation of the poor respondents' rights. But sometimes what you see, and could be a reaction, for instance, in not giving notice of the press release days ahead of time, is no good deed often goes unpunished by the staff, and there have been numerous instances where, you know, trying to be reasonable with the other side comes back to bite us. And what we also don't, isn't in the discourse here and isn't the front page in a Wall Street Journal article, are some of the tactics that are taken by defense counsel in some of our investigations, where we receive privilege logs for literally almost, in one case, every single document that the company was producing, where it takes months, sometimes close to a year, to get the documents, where you have company counsel coming in and representing every single witness from the low-level employees to the CEO, in some cases even the board. We see frequent assertions, dancing around reliance on privilege, but not an outright assertion of the attorney-client privilege. And so we are hamstrung and have urged companies, if you have a genuine reliance on counsel defense, it's in everyone's interest to come forth and identify the facts and waive the privilege. So we don't want to bring a case if there is that defense. And in our office, there actually was that defense raised and skirted around and alluded to for 2 years. And finally, they took what we said in good faith. They actually came forward, told us what the advice was, and we closed our investigation. And that wasn't through the fault of the staff that it took 2 years. The company just wanted to, you know, play it both ways, frankly, till they got new counsel after 2 years and did the right thing. So I think that just illustrates a little more insight into why some actions may seem punitive or retaliatory or unreasonable or unfair. It comes in a context of a lot of behavior that is engaged upon by defense counsel. Nobody in this room, but other people.
We need to take our show on the road, in other words. So they will know these points. Okay, and then Gina.
I'll just go, go quickly, and I do think, we are a civil law enforcement agency, and I think the public is depending on us to make sure that we investigate things thoroughly, that we are aggressive, that we are holding people accountable. I think that it has true value in society and in culture, and that is a lot of what we're getting at with a lot of the different new some of the new things that are being rolled out. I think we've been asked to do more with less, and that's exactly what we have to do. So.
Okay, well, we're at our time. Thank you all for being such good sport.